Going through a relationship breakdown can be traumatic. The emotional roller coaster people find themselves on as they... It's important to understand how the law deals with asset division, the way in which an individual's circumstances tend to change post-separation.
Most stressful and painful ordeals. The cost of legal advice and the property settlements compound the stress and strain. In Australia, the patterns of marriage and divorce have changed significantly over the last century. Changing social attitudes towards marriage, along with major changes in divorce laws during the 1970s, resulted in a surge in the divorce rate during that decade, according to the ABS. The ABS says that based on recent trends in divorce rates, it's estimated that around 1/3 of all marriages in Australia will end in divorce. Financial Spectrum's Brenton Tong says separation comes with two major consequences. First, there's the emotional impact of the grief associated with the breaking up of the former couple and any children. The other impact is financial.
When a couple divorces, you then have the issue of splitting that economic power between the husband and the wife. In addition to that, you also have the situation where they start incurring separate expenses by themselves. So you may have two lots of accommodation expenses, two lots of utilities, power, water. So your expenses actually go up as a result of it.
Tong finds the end result is that each individual's financial position takes a turn for the worse following separation. Sorting out a property settlement or how the matrimonial assets should be divided is one of the most difficult aspects of a relationship breakdown. The Family Law Act sets out which assets may be divided after divorce, separation, or de facto relationship breakdowns, and the methods by which an asset split can be determined. Everything can be included as part of the matrimonial asset pool, including the family home, cash held in bank accounts, investments, the family business, inheritance, cars, and also debts such as mortgages and credit card loans. Owen Hodge Lawyers' Andrew Banna says upon separation, there are two ways to determine a property settlement. The simplest solution is the separating parties reach an amicable agreement on how their assets should be split via a consent order or binding financial agreement. But in cases where an amicable agreement can't be reached, then a property settlement dispute may be resolved in either the Family Court of Australia or the Federal Magistrates Court of Australia.
So they're the two prime courts that deal with family law issues. And depending on if it's a de facto matter or a married matter, what happens in de facto matters, sometimes it may be determined in the state courts.
He explains the courts adopt a strict four-step process to determine who gets what. In step 1, the court seeks to identify and value the combined assets of the parties. In step 2, the court examines what the contributions of the parties were during the marriage or the de facto relationship. The court then examines the future needs of the parties.
To do that, there's a range of factors in the legislation which the court considers, and usually the weaker party would be granted an adjustment in their favour.
Some of these factors considered for each spouse include their age and health, job prospects, responsibility for the care of children, and financial resources. In the final step, the court takes into account all the factors outlined in the prior steps and makes what it considers is a just and equitable asset split. Similar to how other property can be divided, a couple may reach an amicable agreement on how super should be split. But when an amicable agreement can't be reached, then the court has the power to make a splitting or flagging order.
Now, a superannuation splitting order is an order which is, as the term suggests, the superannuation is split. A flagging order is, I guess, in reverse to a superannuation splitting order, in the sense that a flagging order acts as an injunction to stop or prohibit a trustee from super splitting a superannuation fund.
For couples running SMSFs, there are three key issues that need to be considered in the event of separation. Firstly, a splitting or flagging agreement will need to be reached by the parties or ordered by the court.
So the issues you need to consider is basically who's going to keep the interest in that super fund and what entitlement is going to be paid out to the other party, if any.
After navigating the division of assets within the SMSF, the fund may need to restructure.
It might need to be restructured in the sense of amending the trust deed to take off or remove a trustee, in which case would be either spouse, or it might be the circumstance where the remaining spouse wants to appoint another trustee, in which case the trustee will need to be amended.
Lastly, Banna recommends it's crucial that any party exiting the SMSF obtain an indemnification order from the court.
The idea is for the member who...
A relationship breakdown can negatively affect an individual's ability to secure financial freedom. It's vital that advisors reassess and formulate realistic goals for those clients going through separation and recommend the appropriate strategies to help rebuild their wealth post-separation.